How you doing today?
Good, good.
Okay. Well, I just to get my recorder working on. It's okay.
Judge, this is a question from Molly Beth, who's covering your race, so my
Sure.
apologies. But she wants to know, have you ever presided over a case involving attorneys who have close or familiar relationship with you, or attorneys who are campaign donors? Have you ever presided over a case with attorneys?
Well, first on the close familial ties, I can't. I'm prohibited by our Code of Judicial Conduct. My mom and my dad were both attorneys. They certainly have not practiced in front of me. My uncle is an attorney, and so not only have I recused myself from any case that would involve, I don't know if I've recused, I've certainly not sat on any case involving my uncle, and he has a law partner, and I have gotten out of any case that would have involved him either. So.
Including the attorney representing those people?
Attorney.
So if you have a familiar relationship with the attorney representing somebody in a case, not just the people involved, not the people.
Right, that's what I was talking about, the attorneys, exactly. Right.
And then same question for just any campaign donors.
I am unaware of any campaign donor attorney that has appeared in front of me. I'm not aware of any attorneys that have contributed to my campaign that have been in any case that I've handled. Certainly not since I announced last June. I'm just unaware of any.
And then so because the Supreme Court's rules now I think allow justices to sit in cases where there are donors who have contributed. Do you agree with that rule, and do you have any thoughts on that?
Well, we have a recusal rule in Wisconsin, and it's important that the voters understand that we do have a rule. And the rule requires every justice and every judge on the circuit court level where I am now to determine in every case whether there's any reason that they cannot be impartial. And if I make that analysis with every case that comes through, and if there's any reason at all that I determine that I cannot set aside any personal feelings that I have either about a party or an issue in the case, I must step aside and let another judge handle that. That's what our rules require.
I'm interested in your thoughts on the Heller decision. That's the U.S. Supreme Court decision that says that the Second Amendment is an individual right rather than like a militia or group right. Do you believe that decision was rendered correctly?
Well, I haven't read it in detail, and as you and I talked last summer, I don't comment on whether I think a court correctly decided a case unless I've had a chance to read all the briefs and read the decision completely to come to my own independent thought as to how I might have decided the case. What I can tell you about Heller is it's the law of the land, and I'm required to follow it as with any U.S. Supreme Court case that deals with an issue of constitutional law.
How important do you think it is for a justice to be pretty familiar with that law, given it's how recent it is and how it speaks to a fundamental right?
Well, it's important for a justice to be very familiar with that decision when handling a case that addresses the same issue that Heller addressed. So there are lots of cases that individual judges are not particularly familiar with until they do the research in a particular case where that issue is in play. So it's not important for a candidate.
You haven't had a case come up where you needed to study that?
No,
the Heller decision.
I have not had a case that has involved Heller at all.
Have you had many cases that dealt with concealed carry or open carry questions?
I have one case right now that deals with, and it's an ongoing case, so I'll say very, very little about it other than that it involved an individual who had, I believe it was a handgun, sitting in the open on, I believe it was on the passenger seat, and there's presently pending in my court a motion to dismiss that case based on the current law in Wisconsin, and I'm not even sure if the state has responded to the motion yet. I certainly have not begun to do the research on that case, and I wouldn't say anything more about it now anyway.
Your opponent recently tweeted that, I can't remember the exact phrase, but common sense reform for guns would be a good thing. I wonder what you think of her saying that, in that it appears to be taking a position on what the state should do in terms of policy.
Yeah, I think it's consistent with the way she's conducted herself in this campaign, talking about a lot of issues, and I think it's troubling. I think it's unfortunate. I think that it will cause her, it will cause her problems now on the circuit court bench. If she were to win a seat on the Wisconsin Supreme Court, would cause her problems under our recusal rule. And the Our recusal rule requires you to recuse yourself if, as a judge or as a candidate for judicial office, you have made a statement that would appear to commit you to a position on an issue that comes before you. So she has talked about, she said over and over again, well, I'm not talking about any case that's pending. That's not what our rule, it's not the only thing our rule deals with. Our rule talks about making statements that would appear to commit you to a position on an issue. And she's talking about lots and lots of issues, and that's one of them.
After Florida, lots of people have been wondering how should this nation grip with the differences between, gun violence, particularly in schools or in mass shootings, against the Second Amendment right to bear arms. In your view, are there things that the courts can do to curb or address gun violence?
Well, in my view, there are things. Courts don't do things. That's the first thing. Courts deal with cases that come before them, and when a case is in front of the court, the question is twofold. One, what does the law say that's in front of the court? And secondly, is that law lawful or not? And those are the questions that the court answers. And so the questions about what, if anything, should we do in society in reaction to the Florida school shooting, which was incredibly tragic, is a question that is to be debated in society, within communities, and ultimately by Congress on the federal level and state legislatures and governors and the president to determine whether any changes in the law would be appropriate. It's not the court's role to determine what the law should be. The court's role is to declare what the law is based on what work the two political branches have already done.
That's all I have for you today.
All right.
Thanks for your time.
Everyone. Thank you all.
Appreciate it.